Hello everyone, my name is Maddie Byrd, and for this New Mexico law presentation, I chose to do it on wills. 76% of American adults do not have a will or formal estate plan. Introduction. A last will and testament is a legal document that determines how your assets and property will be distributed after death. A will is a very important part of an estate plan, which handles power of attorney and healthcare directives. Here are some broad legal requirements that are usually expected throughout the country, but it does vary by state. We'll get into Mexico's specifications later. The name given to the author of a will is referred to as an intestate. In the case that a person dies without authoring a will, the person's assets and property will be divided according to laws of intestate succession. In order for a will to be considered valid and legal, formalities such as the following are required. The testator has capacity and is in sound mind. The will must be in writing. The testator must sign the will, and the testator's signature must be witnessed. These are New Mexico's legal requirements for a will. Very similar, but a little more specific. In order for a will to be considered legal and valid, New Mexico has some specific requirements of their own. Must be 18 and over, and be of sound mind, meaning you understand your assets as well as who you wish to inherit them. The will must be in writing, typed and printed. It must be signed by the testator. 2 witnesses who are 18 and over are required, and the will must be signed in the testator's presence. It is highly recommended that the witnesses be disinterested, meaning they do not stand to inherit anything from the will. Wills are not legally required to be notarized, but in the event that the estate goes through probate, a notarized will along with an affidavit makes the will a self-proving document. In the event that the will is not notarized, the court may have to track down the witnesses to verify signatures after the testator's death. Executor of a will. An executor, also called a personal representative, is named in a will to oversee the administration of the deceased's estate. If no will exists, a court appoints an administrator to perform the same duties under state intestacy laws. Executors are typically trusted individuals chosen by the deceased, often family members or close friends, and must meet legal requirements such as being of adult age and mentally competent. Now let's review some types of wills that are recognized in New Mexico. But before we do that, I want to talk about the term trust. It comes up a few times. In legal terms, a trust is a fiduciary agreement where a person, known as the trustee, holds legal title to property or assets for the benefit of another person or group, known as the beneficiaries. This also allows the creator of the trust, known as the grantor or settlor, to control exactly how their assets are managed or distributed. So now we go on to types of wills. The most common type of will is known as a standard will, and that designates an executor, names beneficiaries for property, assets, and appoints guardians for minor children. A testamentary trust will. This type of will includes instructions to create a trust upon your death. This is highly effective will in the event that you want to leave assets to minor children or dependents, but you also want to dictate exactly when and how they receive their funds. Next, we have a joint of mutual will. This will is a single document created by married couples or partners that disposes of their combined assets. Once one partner dies, this type of will usually restricts how the surviving spouse or partner can change the terms of the document regarding the shared property. A pour-over will, normally used in combination with a living trust. A pour-over will acts as a safety net, dictating that any assets not properly transferred into your trust during your lifetime pour over into your trust upon your death. Living will. A living will is an advanced healthcare directive that outlines your wishes for end-of-life healthcare and/or life support measures. Contesting a will. When a will contest occurs, it is considered to be a formal objection to the validity of the will. This occurs when the arguably does not match the testator's intentions. Common reasons why a will is contested: the testator was incompetent, insane delusion, or it was undue influence, coercion, fraud, or improper execution of will under the law. It is possible for someone to challenge a portion of the will or the entire document. In the case that a will is contested, contestors may attempt to prove an objection through either direct evidence or in the form of witnesses or circumstantial evidence. In order for a contestor to prove insane delusion, the contestor must show that the testator consistently believed the alleged facts had no basis in reality, as well as the delusion made an impact on the testator's disposition of the property. It is important to note that insane delusion is different from a mistake or incapacity. Next, we have undue process. Undue process means the testator's desires are overturned for those of another person. Undue influence is most commonly proven by circumstantial evidence rather than direct evidence. The contestor must prove that another person influenced the testator, and that influence caused a provision expressing the intent of the influencer rather than the intent of the testator. I talked to a lawyer recently, and in order to avoid a will contest, there is a clause that you can add to the bottom of your will, and it's called a no contest clause, and it prevents a beneficiary from inheriting under the will if they unsuccessfully challenge the will. So what happens if you die without a will in New Mexico? Well, that brings us to intestate succession laws. Assets that pass the surviving co-owner or beneficiary the deceased names. Property the deceased transferred to a living trust. Property the deceased owned with someone else in joint tenancy. Life insurance proceeds with named beneficiary. Securities held in transfer on death account. Real estate which had been transferred on death deed, payable on death accounts, and funds in an IRA, 401k, or other retirement account with a named beneficiary. In New Mexico, under intestate succession laws, it depends who will get what based on if you have living children, parents, or other close relatives when you die. I found this table on NMSU's website when it comes to will planning. It was a very helpful document if you guys want to review that. This table exhibits how property is distributed without a will. Single individuals, including widowed, divorced, and unmarried, with children or children's descendants. All goes to the children in equal shares or to descendants by their representation. Without descendant but with parent, it goes to surviving parents or parent. Without descendants or parent but with sibling, everything goes to siblings in equal shares. If any are deceased, then to lineal descendants of siblings. Example, if the siblings have children or spouses. Without descendants, parent, sibling, or descendant of sibling. 1/2 to maternal grandparent or grandparents, then to heirs of those grandparents. 1/2 to paternal grandparent or grandparents, then to heirs of those grandparents. None of the above, everything goes to the state of New Mexico. Married individuals, without children, everything goes to the spouse. And married individual with children, community property, all to spouse. Separate property, 1/4 to spouse and 3/4 to children, equal shares. This brings us to community property. New Mexico is a community property state. In the event of a spouse's death, community property laws dictate the surviving spouse keeps half of the community property, while the other spouse's half is distributed according to their will and estate plan. In New Mexico, assets and debts acquired during marriage are jointly owned by both spouses. This impacts property division in divorce and inheritance. Debt responsibility. Debts incurred during the marriage are considered community debt, which means both spouses are responsible for repayment, even if the debt is in one spouse's name. Assets owned before marriage, inheritance and gifts, are considered separate property. However, separate property can lose its status if it is incorporated with community funds. Legally changing or revoking a will. Common reasons why changing a will would be necessary: marriage or divorce, birth of a child or adoption, property purchase, sale or loss of property in an existing will, changes to finances, death of a beneficiary or executor, appointing a new guardian for a minor child, or moving to a new state or country, as they have their own laws pertaining to wills. Making changes to a will. If you would like to make changes to a will, you would add a document called a codicil. A codicil works somewhat like an amendment. A codicil is subject to the same requirements as a will. In the case, you will need witnesses and signatures. Codicils are not necessary in current times as they often add confusion to a will. It is recommended that you draft a new will to avoid the changes, time, and money a codicil requires. A new will simplifies will intentions and revokes all previous wills. Revoking a will. Destroying a will does not invalidate it. There may be other copies other than what has been destroyed. Probate court would assume that a testator intentionally destroyed it if the will is missing. Someone who wants to argue that a copy of the same will should be honored will need to produce evidence to refute that presumption. Thank you all for your attention. If you have any questions or would like further clarification, please don't hesitate to message me.